We're about to start. Let's not overshoot. All right, all right. So thanks for being here for the plenary. We have an exciting plenary in front of us, great speakers and great topic. So we're going to start right into it. The topic is about overshoot, which is obviously a very important topic from various point of views. Our communities actually work on this since essentially several decades. But this concept has evolved in time as policy and technology has also evolved. And so it has opened up a lot of new research streams that our community has contributed to, that should also contribute more towards in terms of climate impacts of overshoot, societal impact of overshoot, and the implication of overshoot for mitigation strategies. So we have two great speakers today trying to give us some clarity of where research is going from different point of views, different perspectives, which I think is great. And then we're going to have some times for quick Q&As. Before then, there's a second very exciting plenary ahead of us. So let's just get into it, and I will give the floor to Lavanja Rajamani, who is online. Unfortunately, she couldn't join us. She's in Oxford. She's a professor in Oxford, and she's a legal scholar. So she's going to guide us through what is now a very important concept, which is the legal framework of overshoot. Lavanja, take it away.
Thank you, Max, for that introduction, as well as inviting me to be part of this very exciting conference and plenary. What I'd like to do in the next few minutes is to take you through the Paris Agreement's temperature goal, which of course I know you're all very familiar with, but I'd like to contextualize it in the context of overshoot, both in terms of how we might interpret the Paris Agreement's temperature goal for overshoot, as well as the continuing relevance of the Paris Agreement's temperature goal in the light of, or in the sort of eventuality or inevitability of overshoot. I will then talk through some of the, illustratively, some of the implications of overshoot and what implications that has also for the regulatory and governance architecture, and then move on to discussing quite quickly, again, in a very sort of snapshot way, because I only have 10-15 minutes this morning, to take you through some of the limits and gaps in the international framework in responding to overshoot, and finally, just providing some hints as to what potential avenues there might be for developing this legal framework and concretizing the legal framework that already exists in relation to or interpreted in favor of sort of regulatory architecture that addresses overshoot. So to start with the Paris Agreement's temperature goal, as you're aware, the Paris Agreement's temperature goal is to hold the temperature increase to well below 2 degrees centigrade and to pursue efforts towards 1.5 degrees centigrade. What the Paris Agreement's temperature goal does is to concretize the UNFCCC's ultimate objective of holding greenhouse gas concentrations at the level or stabilizing them at a level that would prevent dangerous anthropogenic interference with the climate system. So the Paris Agreement and the temperature goal contained in Article 2.1a merely concretizes the goal, the ultimate goal that was expressed in qualitative terms in the UN Climate Change Framework Convention on Climate Change. Now, the Paris Agreement's temperature goal is a single composite goal. There are some scholars who believe that it might actually be two different goals, well below 2 degrees and 1.5, but that's not the interpretation that I would assign to it. It's a single composite goal, but it has two elements. And over time, what the UN climate change regime has done to the Glasgow Climate Pact, the Sharm el-Sheikh Implementation Plan, and other COP decisions is to shift the emphasis towards 1.5 degrees centigrade within that sort of spectrum from well below 2 degrees to 1.5 degrees centigrade. And the International Court of Justice advisory opinion earlier this summer in July held or interpreted 1.5 degrees centigrade as the, and I'm quoting, agreed primary temperature goal, and also the scientifically based consensus target that parties have agreed on. And there's a huge amount of salience to be attached to 1.5 because it guides the interpretation of the treaty. And as the ICJ held, parties are to ensure that nationally determined contributions, when taken together, are capable of achieving the temperature goal of limiting global warming to 1.5 degrees above pre-industrial levels. So what do we make of this temperature goal in the light of the fact that overshoot is actually inevitable? Is the Paris Agreement's temperature goal then redundant, frustrated, and therefore irrelevant? I would argue not. As the ICJ has held, the 1.5 degree goal is the primary agreed temperature goal. But this 1.5 degree goal lies within a range from well below 2 degrees to 1.5 degrees. So merely because it overshoots 1.5 degrees doesn't mean that it automatically frustrates the sort of temperature goal captured in the Paris Agreement. And it is also worth keeping in mind the temperature goal is set at a level that would prevent or avert dangerous anthropogenic interference with the climate system in the language of the Framework Convention on Climate Change, and is also tied to a level that would significantly reduce the risks and impacts of climate change. So there is a qualitative element to the goal as well. The 1.5 degree temperature goal doesn't actually identify a deadline by which well below 2 degrees centigrade or 1.5 degrees centigrade should be achieved. And there is also no precise timing identified in the Paris Agreement for net zero to be reached. Article 4.1 so refers to the second half of the century, but doesn't actually identify a precise timing for net zero to be reached. So merely because overshoot occurs, that we go beyond 1.5 degrees centigrade, doesn't necessarily then mean that the Paris Agreement's temperature goal is irrelevant. The goal is still achievable, but the goal is achievable from above. And that is very much well within what the Paris Agreement envisages. So what are the implications of overshoot then? So we've established that the 1.5 degree goal remains relevant, but what are the implications? And again, this is just illustrative, but there are several implications to overshoot. As of course, you're all familiar with, every increment of rise above 1.5 degrees centigrade increases the likelihood of high impact climate risks, some of which are irreversible, of course. And many tipping points will then be triggered. There is increased loss and damage. There will be increased burden shifting to vulnerable countries and communities, increased burden shifting to future generations. There will be an escalating breaches of the full range of human rights that are already being challenged in courts and will continue to be challenged in courts. There will therefore be an enhanced need for support, and there will be an enhanced entitlement to reparations and compensation for the harms that have befallen these vulnerable communities and even future generations. And there's an enhanced need, therefore, for robust accountability mechanisms. In addition, achieving 1.5 degrees from above will mean enhanced reliance on CDR methods and an increased likelihood that high impact risks of climate change will actually outweigh the risks of many geoengineering techniques such as solar radiation modification, other high risk technologies. So what all of this suggests is that we need a very robust and robust governance architecture, regulatory architecture, legal architecture to address these increased risks and address these increased risks, not just of enhanced climate change, but also of trying to bring temperatures back to 1.5 with increased reliance on CDR and potentially SRM. But is the legal framework actually up to the task? There are very significant limits and gaps in the international legal framework, and I can start by identifying just some of the gaps in the UN climate change regime. Again, I'm sure many of you are familiar with this. The goal itself, there is no guidance in the goal in Article 2 on duration and magnitude of overshoot. So while the goal actually acknowledges that there might be a role for achieving 1.5 from above, at least implicitly, there is no guidance on what the duration and magnitude of overshoot should be. The ambition of individual NDCs, while the ICJ has held that these should add up to an adequate contribution to 1.5 degrees centigrade, there is very limited adequacy review of NDCs within the Paris Agreement architecture, governance architecture itself. As far as fairness and equity concerns are to be considered, there are very limited avenues to address burden sharing, intergenerational fairness, or to support or compensate vulnerable countries. What we do have in terms of, for instance, the loss and damage fund, or for instance, in relation to fairness, the transparency requirements around and the narrative requirements in Decision 4 CMA 1 in relation to providing information on fairness. These are all very limited avenues to address burden sharing, limited avenues to address intergenerational fairness, and to support and compensate vulnerable countries. As far as accountability is concerned, again, the Paris Agreement contains very few obligations of result, and there is very limited scrutiny even within the compliance mechanism, except for binding procedural obligations. So as a regime that is sort of addressing climate change itself, as it currently stands, the Paris Agreement is fundamentally limited, of course, and it is even more limited when it comes to addressing overshoot. There are also significant gaps in international law, in particular at the technology interface, in relation to, for instance, the extent of reliance on carbon dioxide removal. There might be some implicit regulation that I can speak to in a minute in relation to reliance on CDR, but there is no explicit regulation of this either within the climate change regime or outside. There are needs, for instance, even for procedural requirements in relation to transparency, how much CDR are states proposing to use, what kinds of CDR, have they sort of taken the risks and uncertainties into account, how much CDR, how are they going to fund it? None of this we currently have sufficient sort of procedural requirements of transparency in relation to. As far as, for instance, solar radiation modification, again, this is not, this technique and other techniques of a similar nature are not currently regulated explicitly under international law, which is a significant gap because these kinds of technologies, as the risks of climate change and high impact risks of climate change escalate, the high impact risks of climate change might actually outweigh the risks of some of these sort of techniques. And so we might actually be in a position 10, 20 years down the line where we have to or might potentially consider relying on them. And we don't have any explicit regulation of these techniques. So there are very significant limits and gaps in international law, but there are some potential avenues for further development. First of all, it is worth noting, as the ICJ did and spent considerable sort of time elaborating on, there is an international legal framework that extends beyond just the Paris Agreement and beyond the UN climate change regime. In particular, states have binding customary obligations in relation to preventing harm to the global environment and also to cooperating to prevent such environmental harm. What this translates into is a very objective, stringent, and demanding standard of due diligence on states, which is shaped in particular by best available science, by the Paris Agreement's temperature goal, highest possible ambition, progression, common but differentiated responsibilities, and also principles of international environmental law, such as precaution. And this can be sourced to the International Court of Justice advisory opinion in July, but also the International Tribunal of the Law of the Seas advisory opinion last year. All of this translates into tighter expectations of states, which suggests in the context of overshoot that overshoot should be as limited in duration and magnitude as possible. It also translates into increased expectations in relation to a time frame for peaking, for potentially net negative rather than just net zero greenhouse gas emissions, of higher NDCs, more ambitious NDCs, and more ambitious support provided to sort of vulnerable communities and people. This also translates potentially in relation to CDR on substantive guidance and procedural requirements relating to reliance on CDR. The ICJ also held that state responsibility can be engaged, so there is some potential for accountability too when there are internationally wrongful acts. So when the standard of due diligence is actually breached, state responsibility is engaged, and it could potentially lead to reparations. So just to conclude, overshoot doesn't render the 1.5-degree goal or the Paris Agreement irrelevant. On the contrary, overshoot suggests that we should double down on the Paris Agreement and double down on the 1.5-degree goal, which is very much achievable or attainable from above. It also suggests that the framework suggests that the duration and magnitude of this overshoot should be as limited as possible. But what overshoot does do is exposes the limits and gaps in the international legal framework. And as an international community, we do need to address these limits and gaps in the international legal framework to comprehensively and decisively address overshoot going forward. There is some implicit regulation in some areas because of customary international law norms in addition to the Paris Agreement, but there is potential for and a need for further legal and regulatory development across the board. I will leave it there. Thank you very much for your attention.
Thanks, Lavanja. Perfectly on time, giving us also some clarity about the Paris Agreement in the context of overshoot, also highlighting the role of this community as these legal issues become more and more relevant as well. So now turning to Nico Bauer, senior scientist at PIC, telling us a little bit more about the scenario work related to overshoot and also future direction of research.
Thank you very much. Good morning, everybody. So that I will not overshoot my time budget, and therefore I have an accounting system here. So the overshoot issue is, it does not work well, or does? Okay. So I reverse my timer. So the overshoot, as Lavanja already said, the obvious, it is there. It's now not anymore about avoiding overshoot. It's about managing overshoot and still complying with the 1.5-degree target. This has a lot of issues regarding IEM models, but it is not only the IEM models, it's also our interconnection with the Earth system modeling people from working group 1 of the IPCC, and it is also about the impacts and the adaptation issues that are very important. And since overshoot is related to many general problems, it throws us also back into history and what we have done previously in different model comparison exercises. And this is a figure that Max put together in a paper that is currently under revision, and it shows for different model comparisons that we did over the time, there were different temperature targets. Yeah, and it starts in 1997, so really long time ago. There, people were more interested into emissions and CO2 only concentrations. And it was, so to say, more in the direction of 2.5, 3 degrees stabilization. Then we moved on with Copenhagen asking for well below 2 degrees. And there, it turned out that we should have also greenhouse gas concentrations or the other forces. And then also the CDR option was introduced in order to have then also the negative emissions available. And it turned out these targets are best achieved when you have international cooperation and joint implementation of the targets. When the Paris Agreement was agreed on, it asked for the 1.5 degree. And this is what the different model comparisons then looked at, especially with carbon budgets. But you also see that only 2 of these comparisons looked into different implementations of overshoot or non-overshoot. And this is something that we have to work on now with perspective on how to bend down the curve towards the 1.5 degree, again, with a limited or rather limited or overshoot, and probably also in the distant future, by when to get back to 1.5 degree. A lot happened during this time also. CO2 concentration went up in the atmosphere. The estimates of the impacts and the damages increased a lot. We have lots of technological progress, especially in renewables and electrification. And we have improved the IEMs also with respect to including more carbon fluxes and so on. So the state of the climate policy today is the 1.5 degree safeguard is trespassed, basically. The forest carbon sink absorbs less CO2 despite slower deforestation. The emission gap widens and the near-term policy ambitions weaken. Even the European Union has now relaxed the target. So that speaks, so to say, it runs then the risk of an even higher overshoot, and the implications need to be made clear, but still low carbon technologies improve beyond all expectations, and we are today in a much better situation technologically to achieve all these targets. Also, research on CDR has improved a lot. We are not there yet, but it has improved. And in all of that, we have now a delay of the IPCC AR7, especially working group 3 is probably not going to make it in time for the GST2. This is an issue in itself. Okay, on overshoot, Lavanja already mentioned it. We can differentiate 2 different scenarios, one with and one without overshoot, in a very simple fashion where we have a pair of scenarios. And there we can then analyze or also put a constraint on the magnitude and or the duration of the overshoot. It should be noted that the CDR begins before the overshoot begins. And usually in non-overshoot scenarios, the CDR begins earlier. So the ramp up is even stronger in the near term in the non-overshoot scenarios. We have done this kind of analysis in a paper recently. Here we started in 2020, after 2020, to deviate with the scenarios. This is one where we have the CO2 carbon budget exactly the same between the 2 scenarios. Yeah? And then we can run this through different models, like this is results from a climate model, the UVIC model, Earth system model of intermediate complexity, and we can look how well is the reversibility. Yeah, and here it turns out this 20% of the initial, of the maximum peak is still present when the carbon budget are equalized exactly. Yeah, so we have 0.4 degrees maximum peak, then a little less than 0.1 at the end is still there. And this is explained actually not by the differences of CO2 emissions, but other greenhouse gas. We neutralize this, then it's exactly the same. We can put this to any other kind of natural systems model. We can also look for sea ice, which is very sensitive for the ocean currents. We can also look for environmental ocean variables like coral reefs and so on. We looked in this, and all these different variables have different reversibilities. Yeah, for example, weakening of ocean currents like the AMOC hardly recovers by 2100. Yeah, and these different time scales and these different reversibilities are then very important to consider. And also look at the GDP losses, and here it's important for the non-OECD countries, the mitigation costs are higher, and they are especially higher in the non-overshoot scenario in the near term. So the burden lies especially with developing countries. This, however, is a scenario where we use uniform carbon prices throughout the world. If we differentiate this, take into account equity considerations, then change. Now we have scenario MIP. Scenario MIP does something different because it explores varying or the alternatives under varying narratives. And one thing that is very important to consider in the context of scenario MIP, before you look at all of this, please take a look here. This is 2030, and there we harmonize the emissions. Oops. And that means this is also important for the global stocktake in 2028, that the emissions do not vary too much in 2030. Afterwards, they vary a lot, but not in, so much in 2030. This is important for the IPCC process also. Then we have these different scenarios. I know you cannot see it. Okay. This is a scenario that aims at the lowest. Okay. So the narratives are now shifting. This is where we try to achieve the lowest possible near-term emission reductions. This also includes changes in dietary choices, a low meat diet, and therefore it is possible to bring down the emissions very, very strongly. However, in the long term, we do not want to see too much terrestrial and also marine CDR, and therefore the net negative emissions are limited to take into account of the sustainability constraints. We also have a scenario with much higher overshoot. It aims to return to 1.5 in the longer term. Excuse me, I should add. So this now lowest scenario is very likely not to fit with the C1 criteria. So it's going to have a higher overshoot. Then, so we go beyond 1.6 degree temperature anomaly, but return back to and below 1.5. Yeah, so that would be in that sense Paris compatible. This scenario with the higher overshoot would probably not achieve 1.5 in 2100. The requirements here are completely different than in this scenario. So for example, which countries, which regions, and which technologies should achieve all these net negative emissions? These are important questions for the governance, the equity concerns, and something that we also need to explore and spell out in our scenarios. When we have these scenarios, they will be fed into Earth system models. And these in turn are going to be used then also in the impact models. And there is a lot to be expected from these new scenarios, because they are going to be emission driven. And we are going to have also the land use patterns to be transferred to the Earth system models. There is much dispute on the consistency between these models, because it is not only an interface, it is an overlap of systems. Kind of we grow trees in our land use models. We transfer the land use pattern to the Earth system models, they compute carbon uptake, again, based on the land use patterns. And these carbon uptakes, the carbon fluxes, are not consistent with each other. There's much uncertainty also in the Earth system models. How high are these carbon densities? So when you look at this figure, you probably cannot see all the many different lines. So what happens in Earth system models when you reach net zero emissions? Yeah, over time, you see there is net zero CO2 emissions. There is a slight decrease in temperature over time, but there's also a huge variation. Yeah, you look at this scale, and this was already published in the last IPCC report. And when we feed now these Earth system models with these precise scenarios, we may get very different outcomes. And a lot of variation, a lot of uncertainty. These uncertainties also need to be taken into account in our mitigation strategies. Okay, the climate variables will be fed into impact models. These impact models can be used then in turn in economic models, like CGE models, to derive damage function. This is from the COACH project. And what you can see is also there's a huge uncertainty. So this is the median damage function, and this is the high and the low variant that has been evaluated. This is global. It's also a huge variation between the regions. Yeah? Especially in developing countries, these damage functions are more serious. They are shifted upwards. We can use these functions then in our integrated assessment models and combine them with the dynamics of mitigation and ask the question, okay, in overshoot or non-overshoot scenarios, how are the patterns of costs over time? Yeah, and this is very important for policymakers to understand, what do I have to expect today, tomorrow, and the day after tomorrow? Okay, so key research, we have to look into IEM scenarios, and we have to improve them. We probably have to go beyond 2100 to extend also the period for the duration of the overshoot. We have to look a lot on residual emissions, improve the CDR option modeling, and the carbon fluxes. What are all the carbon fluxes that we include? Do we have a full representation? Then we will have a new set of as low as plausible scenarios. How low can we go? That should then not compare with the overshoot scenario, because that would be a contradiction with this. But we should have scenarios that explore this lower space explicitly, having an overshoot beyond the 1.5 degree. We need to understand the causes for the higher near-term emissions, because this explains what we have to do to avoid them, yeah? Including the policy dimension. And then we need to map out for different scenarios, different degrees of overshoot, what are the requirements on governance, technology, development, economics, and so on. Because policymakers then have a clear picture. If I choose this path, these are the requirements. If I choose this path, these are the requirements. When we connect to other communities, we have to improve the interfacing with them. We have to have a careful assessment of the CMIP7 runs and use a whole set of models, including small climate models, EMICs, and develop emulators. We need to an improved integration of the impacts, and then identify the risks and analyze hedging strategies in order to have a better prepared analysis that we can provide to policymakers. So thank you very much.
Thanks, Nico, for being in time. As we see, as with the carbon budget, our screen budget is being shrinked as the session progresses, but we are still alive, and the session is still alive, as the Paris Agreement is still alive. But we have about 10 minutes for Q&As. So please raise your hands and we'll come along, myself and all the others.
Thank you. I feel I should add a little. I just wanted to add a little comment on what you said about AR7 being delayed. Actually, we don't know. The thing is that we don't have a timeline. At this point, we have an agreement on 1 year at a time. So just to add that little nuance to your bullet about AR7. Thank you very much.
Thanks for the addition. I'm not so much into the process detail.
Yes, let me go around, maybe in this part of the room. Carl, Rawad.
Thanks. Great session. We have a lot of things to flag, but I have a question to you, Lavanja, because you mentioned in passing, or you contextualized solar geoengineering a little bit into a basket of a discussion on overshoot, and I would like to challenge that a little bit because I feel it might be slightly oversimplified. I mean, obviously, to start with, solar geoengineering will not help to achieve the objective of the convention and might represent dangerous anthropogenic interference in itself. But then also presenting it in that risk context kind of might be a slight misrepresentation of the risks of solar geoengineering, which start with governance and are ultimately linked to questions of security, and this being a military technology, also basically strongly interacting with questions of global politics and respective dynamics. While at the same time, kind of this risk idea of introducing it in a scenario perspective may be not actually characterizing the risks of solar engineering well enough, which may also lead to mitigation deterrence, for example. So whether or not it's actually appropriate to contextualize it in overshoot, and if it even was effective to tackle high climate risk outcomes, I think are open questions. So I wanted to ask you if you want to provide a bit more of a nuance on that question, if this was possible. Thank you.
Please go ahead.
Thank you for that. I mean, I completely agree with you about the risks of solar radiation modification, of course, and this is not meant to, at least my comments were not meant to sort of paint that in a sort of plausible or, in a light that is sort of more receptive to solar radiation modification. But I think the point I was trying to make is that it is something that's actively being considered by some states and is being pushed forward, at least in relation to research. And as the risks of climate change in an overshoot scenario sort of escalate, it does to some extent become a question of which risks, at least from a legal perspective, which risks are manageable, which risks are acceptable. So the principle of precaution, for instance, the precautionary principle or the precautionary approach, is centered on the idea of risk. And which risks one accepts in a cost-benefit analysis. And if we get to and right now the risks are such that we would make the assessment based on the precautionary approach that we should not go down the path of, as you're suggesting, should not go down the path of being receptive to solar radiation management because of all the sort of both political, economic, and sort of natural risks that come with it. And the risks of the unknown as well. However, 10, 20 years down the line, the risks of climate change might outweigh those risks. And even if you take a precautionary approach might actually suggest that we go down the path of, these extreme measures to address climate change. So it isn't, I was merely sort of illustrating the fact that in an overshoot scenario with increased climate risks, some of these options which we currently find far too risky to go down the path of might actually become risks that we actually start considering because the risks of climate impacts, in a high-risk climate impacts and irreversible climate impacts are sort of tremendous. So it's only contextualizing it in that context. And my plea is that, we should, if we are going to get to that stage, we need to start thinking about how we govern it, perhaps even ban it, but we need to think about what kind of legal regulation there needs to be around these sorts of technologies. Thanks.
For which we have very little, unfortunately, right now. Yes, Rawad?
Yeah, thank you. I also have a question for you, Lavanja. So you mentioned the importance of the international law and the ICJ. If anything, we learned these couple last years is that when it goes against the interest of the dominant, then it's attacked very strongly. How do you think that will evolve in the future?
Please.
Evolve in relation to international law, or evolve in relation to the negotiations, or in terms of states? I wasn't clear which kind of evolution you were referring to, but I think in terms of receptivity to the ICJ's advisory opinion, I mean, the ICJ's advisory opinion itself was far beyond what many states, including the states that actually took the case to the ICJ, the small island states and Vanuatu in particular, far beyond what we could have expected, when we went to the ICJ. So there is sort of tremendous hope, in a sense, in international law, and the vision that international law is actually fit for purpose to address existential challenges such as climate change in the aftermath of this very progressive advisory opinion. But you're absolutely right. This is obviously a sort of very progressive opinion, and it goes against the positions held by many of the major emitters, and we saw that in the statements and sort of submissions before the ICJ, and that would suggest that they will have very little receptivity to the sort of interpretations of international law that were placed on these core provisions of the Paris Agreement and customary international law obligations. And we will see that perhaps in the negotiations as well, where there might be more resistance to arriving at COP decisions that are more progressive or push the envelope, because they're concerned about what that might actually mean in relation to interpretations of law as it evolves. Having said that, however, notwithstanding the resistance from some states to sort of these more progressive interpretations, fit for purpose type interpretations of international law, I think the fact that the ICJ has interpreted international law, not just the Paris Agreement, but beyond the customary international law obligations, and even principles of international law, some of which are just soft law principles. The fact that it's sort of arrived at such a progressive interpretation suggests that it will, over time, sort of further strengthen the rule of law, and in a longer time frame, because many of the geopolitical challenges that we're seeing are in the here and now. This doesn't mean it is going to be, continue for the next 20, 30, 40 years, but international law will continue. So I think it's important that the ICJ has put down a marker in terms of development. It's a key milestone in that respect. Thank you.
So in the interest of time, let's take a couple of questions. And if you can take short, I appreciate it. Thanks.
Thank you. My name is Urs Ruth from Corporate Research at Bosch. I also have a question to Lavanja. Thank you for your great presentation. You pointed out that the Paris Agreement leaves the door wide open in terms of reaching carbon neutrality in the second half of the century. And one of the reasons for that was, of course, that the science wasn't there yet. It was not until 3 years later that the special report on 1.5 came. Now, the reference, therefore, was to the best available science, being guided by the best available science. Now we do have that science, and what from your perspective as a legal scholar, what would be a clean way to move forward to consolidate this science that now is available in the context of the future negotiations? Thank you.
Thanks. Steve. Yep.
Okay. Yeah, so also a question for Lavanja. I was wondering if you could say a little bit more about the legal precedent in this space. So you mentioned it was thin, but there's obviously something out there that we can lean on, specifically with respect to the technology constraints. And also if you could give some more examples of the types of constraints that we might envision or consider in the discussion.
Please, Lavanja.
Thank you. So just quickly, because I know we're running out of time, in relation to how we can interpret the Paris Agreement in the light of evolving science, as you pointed out, best available science is something that's sort of referred to in the preamble of the Paris Agreement. There are several references to best available science throughout the Paris Agreement. and in subsequent COP decisions. And the preamble provides context for the interpretation of the provisions of the Paris Agreement, and the ICJ relied on best available science to interpret the Paris Agreement in an evolutionary fashion, in a sort of dynamic fashion, so that the science on the basis of which we're interpreting the Paris Agreement is not sort of static. It's not based on 2015 science, but it's based on 2025 science and going forward. So I think the fact that the emphasis in one point in the Article 2 temperature goal has shifted towards 1.5 is a reflection of an interpretation of the Paris Agreement that evolves with the science. So I have every confidence that at least if that approach is taken, which is a more dynamic approach, more evolutionary approach to sort of interpretation of the Paris Agreement, that we will keep evolving the norms in the context of the evolving science. But I think the one thing, of course, the limits of that are that you can't evolve it beyond the clear terms of it in a sense. So you can't create substantive new obligations where none existed, or you can't create a whole new temperature goal. That will require an amendment of the Paris Agreement. But I think the architecture of the agreement, the references to best available science, the approach that the ICJ has taken very much suggests that this regime can develop with the science. As far as technology and technology constraints are concerned, the ICJ again actually referred to technology in this context and said, well, the best available technology should also be integrated into the policies and measures and actions that states take. But where technology itself poses risks, then those risks need to be taken into account as well, which goes back to perhaps the first question that Carl asked in relation to solar radiation modification too, that we need to take technology into account, but the limits of that are where the technology itself poses some risks that some of those risks we may not yet know about. So there are sort of limits to how far technology can be taken into account, and that's when risks of technology itself are sort of part of the picture. I'm going to leave it there, but I'm very happy to converse on these issues, over email or elsewhere in other fora. Thank you.
Thanks. We have to close, but last few words for Nico for commenting on this comment.
Yeah, thank you very much, Lavanja. The interest in your presentation shows how important the deeper interactions with lawyers and governance specialists is. And we should take into account in our analysis these risks and relate them to general principles that you mentioned and how you apply them, and how to interrelate our quantitative risk analysis on technologies, on climate impacts and all that kind of stuff with the treatment of uncertainties by the more governance and law-oriented people, and how we can then also develop these concepts that you apply further. Yeah, and I think that could be a very important avenue to go.
This is a great ending, Nico. It's a call for also methodological development to try to connect disciplines and account for these uncertainties. So let's give a big hand to Lavanja and Nico for the great talk.